Good afternoon and welcome to the first Holman Webb webinar for 2022. It's the year in review for 2021 and a bit because there was a surprise late starter. My name's John Vanderpoel. I'm a partner in the insurance team at Holman Webb. The cases we're going to be dealing with today are, as I say, mainly from 2021. They concern credit hire, the oft litigated subject matter in the local court between motor vehicle insurers. The late entrant was the second COVID test case appeal that was handed down on Monday afternoon, and my thanks to Margot Toniato from QBE for providing me with a copy of that decision. That was decided by the Federal Court of Appeal. Then there are two matters considering the operation of Section 40 and Section 54 involving the med-mal insurer Avant in the New South Wales Court of Appeal and also in the Federal Court. And finally, there's a further Supreme Court decision in the also regularly litigated question of what a professional services exclusion, in a liability policy actually covers. As we have done with other presentations, we're going to have a few polls which are going to be conducted throughout the presentation. And I think Bill's going to queue up the first one now. We'll give the poll a couple more seconds. And the 56% of people who said, no, I don't need to establish need would be correct. So the decision in the High Court was Arsalan v Rickson and Nguyen v Kassam, and I'll deal with both of the claimants. So Mr. Rickson owned an Audi A3 sedan which was damaged in a collision in with a vehicle being driven negligently by Mr. Arsalan. The repair of Mr. Rickson's car took around 2 months, and during the period of hire, Mr. Rickson hired a replacement car and the hiring charge was $12,000. The magistrate in the local court found that Mr. Rickson needed a replacement car, not only to travel to work, but also to drop off and collect a child at school and for general errands. Mr. Rickson gave evidence that he preferred a European car for safety reasons, but the magistrate found that Mr. Rickson's safety concerns were a preference rather than a need. And on that basis, the magistrate, amongst others, the magistrate also held that the hire car costs incurred by Mr. Rickson were based upon a credit hire rate, which it was said did not represent the market rate of hire for a car from the likes of Avis Budget or Thrifty or Sixt, whatever they're now called. Mr. Rickson was held to be entitled only to recover a hire car charge of $4,000, which was the market rate of hiring the ubiquitous Toyota Corolla. As I think I said in the last presentation, oh, what a feeling. The New South Wales Court of Appeal held that, in fact, Mr. Rickson was entitled to the hire car costs he had incurred of $12,000. In the decision involving Mr. Kassam, he owned a BMW 535i sedan, which was also damaged in an accident caused by the negligence of Mr. Nguyen. Mr. Kassam's case was treated as involving a non-income earning car, although in addition to the use of, and I had to include this, although in addition to the use of his car for social and domestic purposes, he used it for his home business, which included transporting toilet seat samples. As a career that I never knew was available. The repair of Mr. Kassim's car took 143 days, and for 84 days of that period, he hired a Nissan Infiniti Q50 car at the grand expense of $17,000. The magistrate in this case found that a Toyota Corolla would have met Mr. Kassim's needs for a total hire car cost of $7,000, but he rejected the contention that Mr. Kassim's claim for recovery should be limited to the market rate of hire for a Toyota Corolla on the basis that it was not a car of equivalent value to Mr. Kassim's BMW. So the magistrate in that case awarded Mr. Kassim the full amount that he had claimed, as did the New South Wales Court of Appeal. The matters went to the High Court, who hopefully will have brought this subject matter to a close. On the question of loss of amenity, the High Court said there is no justification to restrict the recoverable heads of damage for consequential loss caused by the negligent infringement of a person's property right, so that the loss of use of the lost amenity of use is excluded. In its concern with the consequences of a tortious act, the compensatory principle, which is what we're dealing with in these types of claims, aims to provide the injured party with compensation in a sum which, so far as money can do, will put that party in the same position as he or she would have been in if the tort had not been committed. This general principle has the basic goal to undo, by monetary equivalent, the consequences of the wrong experienced by the plaintiff, so far as is possible. Now, on the question of need, the High Court said that the principles of damage concerned with need for services in circumstances in which services have been provided gratuitously by another cannot be transplanted to replace an analysis of the real loss that has been suffered as a result of damage to a chattel, i.e. a vehicle, including a vehicle, especially in circumstances in which a gratuitous replacement is not available. And I think the reference here was to the attempt to import principles from personal injury cases such as Griffiths and Kirkmeyer, where gratuitous services are provided, into cases involving the loss of use of a chattel. The High Court said the import of this loose concept of need into questions of recovery of the hire car costs incurred is a distraction from the proper focus upon the heads of damage identified by the plaintiff, such as physical inconvenience and loss of amenity of use, and the onus upon the defendant to establish the unreasonableness of the plaintiff's steps to attempt to mitigate the damage caused, the damage by the hire of a substitute vehicle. So as to mitigation of loss, the High Court said, where a plaintiff acts in an attempt to reduce a loss, the onus shifts to the defendant to show that the acts actually taken by the plaintiff were unreasonable acts of mitigation. Unless the plaintiff's actions are shown to be unreasonable, costs that are incurred in an attempt to mitigate loss caused by wrongdoing become themselves a head of damage that can be recovered. However, the High Court said there will be exceptional cases where such loss to the plaintiff will be non-existent or so slight that the hire of a replacement vehicle will not be accepted to be a step in mitigation. And the examples that they gave was where the plaintiff was hospitalised during the relevant period of repair and therefore couldn't use a vehicle, or where the damaged vehicle could have been replaced from idle stock within the plaintiff's fleet of vehicles. The High Court said it will not be hard to infer that a plaintiff who incurs the considerable expense of running a private vehicle does so for reasons of convenience. Similarly, it will usually be sufficient to infer that a plaintiff derives amenity from the various functions used in their vehicle, but particularly an expensive prestige vehicle, in circumstances in which the plaintiff incurred significant capital or ongoing expenditure on that prestige vehicle. So hopefully this decision by the High Court should provide some clarity for the multitude of cases conducted in the local court, but it will have a significant impact where you are concerned with replacement of prestige vehicles, which are, as many who are involved in this area will know, difficult to hire other than at great expense. As I said, the surprise entrant is Laser Clinics Australia, Marrickville and Swiss Re, which is the headline for the cases. There are, I think, 6 individual insureds who ran the test case, and In my view, the decision is almost a textbook on issues such as causation and policy interpretation. With some minor changes, the Federal Court of Appeal upheld the decision of Justice Jaggett, which I thought was also very well thought out, and she delivered that judgment on the 8th of October 2021. The court also delivered judgment in the matter of Star Entertainment Group v Chubb, and together with that decision, the decision covers 350 pages, which made preparing this presentation a real joy. The decision is very helpfully indexed, and as I say, I think it will no doubt be used as a reference point for insurance professionals for many years to come. Sadly, or perhaps not, it's not possible in the limited time that we've got here today and with the other cases that were being considered to cover in detail the decision for each insured. I will at the end of it though give you a pretty brief dot point of what the outcomes were, but the decision does contain some very helpful general guidance as to interpretation of policies of insurance of whatever flavour you happen to be looking at. And for that reason, I think the decision is very helpful. The justices who heard the appeal were Justices Mashinsky, Derrington and Colvin, and the principal judgment is by Derrington and Colvin, with whom Mashinsky agreed, although he does make some additional comments. The principal judgment, as I say, deals with, and the areas of those judgments which I'm going to deal with 4 particular areas. The context of the policy and reading the policy as a whole as an aid to interpretation, and further on the interpretation point, query who the objective reader of a policy is supposed to be, the Contra preferential rule and whether it is in fact a rule of last resort, and of some interest I would have thought to people the question of proximate cause. So, starting with context and reading the policy as a whole, and you'll see this arise again in a later case which I deal with. It's often identified as trite law that the duty of a court when construing a document is to discover its meaning by considering it as a whole. The rationale is that the meaning of any one part of the contract of insurance may be revealed by other parts, and as a corollary, the words of every clause must, if possible, be construed so as to render them all harmonious with one another. Preference is to be given to a construction supplying a congruent operation to the various components of the whole. The principle requires the language used by the parties to be interpreted objectively by considering what the language adopted by them would mean to a reasonable business person in the position of the parties. I think that that should by now be the mantra for every insurance professional when construing a policy of insurance, and it neatly summarises, I think, the principles which have developed over a number of years. But who is the objective reader of the policy? Well, it's not an expert in the field or a lawyer. That's one starting point. The Federal Court of Appeal held that the policies in issue in the proceedings were between insurers and business operators, and for that reason they ought to be construed from the point of view of a reasonable business person, appreciating that and the purpose and object of the agreements. And the court also said that even if a policy's interpretation is to be approached from the perspective of the reasonable insured, in this case a reasonable business person, it cannot be assumed that they would do so in a manner inconsistent with the requirement that I mentioned earlier to construe the policy as a whole. Now, for the contra preferential rule, I think the mistake that is often made in dealing with the contra preferential rule is to apply it immediately before any other interpretive analysis is undertaken of a policy. It was a recurring issue in the appeals as well, and it derived, the contra preferential rule derives from the Latin saying, the words of the deed should be construed strongly against the grantor. And as the court said, where the rule applies, A relevant ambiguity in a contract is resolved by construing the relevant words against the interests of the profferor and adopting the construction which favours the other party. And they said that the justification for the rule is that the party drafting the words is in the best position to look after its own interests, and it's usually the insurer, and it has the opportunity to do so by clear words. It would only be applied for the purpose of removing a doubt, and importantly, it's not to be used for the purpose of creating a doubt or magnifying an ambiguity. The court confirmed that it is a rule of last resort, only to be applied once orthodox processes of construction fail to resolve the ambiguity. Now, proximate cause. The parties agreed or nearly all the parties agreed that the general principles of causation were correctly stated as, firstly, you should look to the proximate or immediate cause, and those terms can be used interchangeably, and not the remote cause of loss or damage in order to determine the liability of an insurer for particular loss. As I said, proximate and direct are used interchangeably. The court said that caused by an accident naturally refers to the proximate or direct cause of the injury and not to a cause of the cause or the mere occasion of the injury. And I should say that proximate cause was a significant feature in the determination of indemnity for each of the insureds involved in these cases. Proximate in this context means proximate in efficiency or effect rather than in time. And the rule is based on the inferred common intention of the parties and would not apply if it would defeat the manifest intention of the parties. So the, excuse me for 1 second. Okay, I'll come back to that question. The proximate cause rule is capable of applying even where the word directly expressly qualifies the word cause in a policy. What's clear from that second last bullet point is that the parties can, of course, contract out of proximate cause by use of sufficiently clear language, but query whether any underwriter would want to do so. And the issue which often arises where there are more than one cause of a loss, and the court also dealt with that here. Absent any provision in the policy to the contrary, if there are two concurrent causes, one being covered by the policy and the other not, the insured may recover under the policy. If the two causes are concurrent and interdependent in that neither cause would have caused the loss, but for the other, the exclusion will prevail, and see the Wayne Tank principle there. Where there are two concurrent proximate causes, one within the policy and the other the subject of an exclusion, and they are interdependent, it is always essential to pay close attention to the terms of any policy and the commercial context in which it was made. Again, construe the policy as a whole. If the policy's construction leads to the conclusion that the parties intended that no cover is provided for any loss caused by a particular cause and the loss was so caused, the policy cannot respond. However, if the party's intention was that the policy would not respond if only the excluded clause, only the excluded cause was the sole cause of the loss, the existence of that concurrent excluded cause is irrelevant. So the outcome for each of the insureds in those cases, Laser Clinics Australia Marrickville, the court held that there was no indemnity because the coverage provision relied upon referred to a catastrophe, and the court held that the COVID situation in Australia was not a catastrophe, as that term is understood. And the prevention of access clause did not apply in relation to diseases, which was specifically dealt with in another section. Meridian Travel, I think, was the only insured that was, and only partially, indemnified, but only for the consequences of an outbreak within 20 kilometres which affected foot traffic. It did not regard 90% of the losses caused by an international travel ban, which was imposed to restrict, well, so the court held, was imposed to restrict disease coming in as being caused by the same risk. It's also worth noting that the JobKeeper payments and the other state-based payments were not recoverable as a sum saved on a business interruption policy because they didn't arise in consequence of the interruption, because those sums were payable regardless of whether there was any outbreak in the area or not. And not finally, but Tap House, which was a Townsville-based pub, I think, or brewery. There was no indemnity available there because there wasn't accidental physical damage, destruction or loss, and the outbreak provision, which was included in the policy, required closure as a result of outbreak within a 20-kilometre radius. The court held that the health orders were not made because there had been an outbreak in that area specifically, but because there had been an outbreak statewide. Market Foods, in that case was slightly different because the insured had only selected cover for content, stock, glass and money and not buildings. And the prevention of access provisions, which otherwise promised cover, were tied to damage to the property insured, and none of that property was damaged. And the outbreak provision required outbreak at the premises to be the cause of the restriction imposed. And again, the outbreak at the premises was not the cause of the restriction. And I don't even know if there was any evidence that there was an outbreak at the premises, but in any event, the restrictions were imposed because of outbreaks statewide. Educational world travel by the liquidated coin, the restriction of access, the court held the restriction of access to the premises did not cause the loss. It was the overseas travel ban that was the proximate cause of the loss because their business was in sending students overseas. And finally, although it's the subject of a separate decision, Star City, public health orders there was no indemnity available because the public health orders were not for the purpose of retarding any conflagration or catastrophe. So again, the court held that the COVID outbreak was not a conflagration, and I can't even say that word properly, or catastrophe. The alternate provision covered the subject matter of illness and excluded diseases declared under the Biosecurity Act. I would have thought very thankfully for I think it was Chubb in that case. So that's the second COVID test case appeal decision. As I say, I'm sorry I couldn't deal with each of the insureds, but as you can see, there's a lot of material in that decision which needs to be absorbed and will no doubt be presented on by others for each insured. And Bill's now going to cue the second poll before I start on Section 40 of the Insurance Contracts Act. Just give that a few more seconds. Okay, good. So 59% of people gave the right answer to that question. If I fail to notify my PI insurer of circumstances that might give rise to a claim, can that failure be cured by Section 54 of the Insurance Contracts Act? It's correct that the answer is the lawyer's answer, maybe. So it's helpful before these two cases from Avant, just to, involving Avant, I should say, to just quickly have a refresh of what Section 40 and Section 54 of the Insurance Contracts Act provide. Section 40 is a ameliorative provision designed to enable particularly insureds who have claims made notified policies, to notify of circumstances and not be caught out by the proposition that the claim wasn't notified within the period of the policy. So section 40 says this section applies in relation to a contract of liability insurance, the effect of which is that the insurer's liability is excluded or limited by reason that notice of a claim against the insured in respect of a loss suffered by some other person is not given to the insurer before the expiration of the policy. Where the insured gave notice in writing to the insurer of facts that might give rise to a claim against the insured as soon as was reasonably practicable after the insured became aware of those facts, but before the insurance cover expired, the insurer is not relieved of liability under the contract in respect of the claim when made by reason only that it was made after the expiration of the period of insurance. And section 54, which many insurance professionals would know by heart, where the effect of a contract of insurance would, but for this section, be that the insurer may refuse to pay a claim, either in whole or in part, by reason of some act of the insured or of some other person, being an act that occurred after the contract was entered into, but not being an act in respect of which subsection 2 applies, the insurer may not refuse to pay the claim by reason only of that act, but the insurer's liability in respect of the claim is reduced by the amount that fairly represents the extent to which the insurer's interests were prejudiced as a result of that act. And subsection 2 concerns acts which could reasonably be regarded as causing or contributing to the loss. So against that backdrop, we start with the decision of Avant Insurance v Burnie. So Ms. Burnie, and I think both of these cases concern breast augmentation surgery. Ms. Burnie sought damages for personal injury that she suffered as a result of, allegedly, as a result of Mr. Blackstock's medical negligence in performing a breast augmentation surgery on her. At the time of the alleged negligence, Mr. Blackstock held a practitioner indemnity insurance policy issued by Avant. However, that policy, which was framed as a claims made and notified policy, expired without Mr. Blackstock notifying Avant of any claim by Ms. Burnie, or even facts that might give rise to such a claim. And Ms. Burnie sought to join Avant to the proceedings pursuant to section 5 of the mouthful Civil Liability (Third Party Claims Against Insurers) Act 2017, New South Wales. And if, as some of you may know, that provision replaces section 6 of the old, also mouthful, Law Reform Miscellaneous Provisions Act 1946, New South Wales. If you feel you need an abbreviation for that, the new legislation, the court seems to have settled on calling it the Third Party Claims Act. So there's a new abbreviation for everybody. The court held that an applicant for leave under section 5 of the Third Party Claims Act must establish 3 elements. Firstly, that there is an arguable case against the holder of the insurance policy, in this case, Mr. Blackstock. Secondly, that there is a reasonable possibility that the holder of the insurance policy will be unable to satisfy any judgment. And finally, that there is an arguable case that the holder of the insurance policy would, if found liable to the plaintiff, be entitled to indemnity under the policy. District Court Judge Strathdy found that there was a reasonable possibility that Mr. Blackstock would be unable to satisfy any judgment, and that there was an arguable case Mr. Blackstock would, if found liable to Ms. Burnie, be entitled to indemnity under his policy with Avant. Avant challenged that elements 2 and 3 had been satisfied. So Ms. Burnie ultimately accepted that there was no evidence that Mr. Blackstock ever gave Avant notification of circumstances that might give rise to a claim before the policy period ended, and no basis to infer that he did. The policy required notification as soon as practicable of a claim, but did not require notification of facts that might give rise to a claim. So that's an important distinction to make, where a policy contractually requires notification of circumstances, the outcome can be significantly different. And in that regard, some policies, some claims made and notified policies do contain deeming provisions as to when a circumstance becomes a claim. So keep that in mind when you're construing policies. The policy also contained a continuity of cover provision. And provided where you, prior to the policy period, first became aware of facts or circumstances that might give rise to a claim or request for indemnity, and you decide not to notify us of these facts and circumstances, then notwithstanding clause 16.1, we will cover you where you continue without interruption to be your, where they continue to be without interruption their professional indemnity insurer. Ms. Burnie contended that the continuity of cover provision effectively made the policy an occurrence-based policy, and that the failure to notify of facts that might give rise to a claim was cured by Section 54 of the Insurance Contracts Act. Justices McCallum and Simpson held the argument proceeded on the basis that the statement in the product disclosure statement set out above was a contractual term requiring the insured person to give Avant notice of facts that might give rise to a claim as soon as reasonably practicable after becoming aware of those facts. And the court said that is simply not what the words say. They went on to say there can be no liability in the absence of any notification at all, and there was no notification. Otherwise, and I thought this was a delightful way of putting it, otherwise the insurer's provisioning for future liabilities would be hostage to what lay in the minds of its insured, but presumably not notified to the insurer. Justice Emmett in the case added some interesting commentary. The reference in the notification provision to Section 43 should not be construed, and many underwriters will know that they're obliged to include references to Section 40 in the product disclosure statement. The reference in the notification provision to Section 40(3) should not be construed as creating a contractual discovery clause. It merely draws attention to the rights and obligations arising under the Insurance Contracts Act, as Avant was required to do. Section 54 operates to prevent an insurer from relying on certain acts or omissions to refuse to pay a particular claim. The section does not operate to relieve the insured of restrictions or limitations, such as the temporal limits within which a claim must be made on the insured in a, so I think it should be insurer, claim must be made on the insurer in a claims made policy that are inherent in that claim. Section 54 cannot be combined with Section 43 to modify a claims made policy to cover a claim arising out of facts and circumstances that were not notified during the period of insurance of the policy. And he went on to say no claim was made against Mr. Blackstock within the first policy period or the second policy period, and no notice of such a claim was given during either period. The claim that was made on Mr. Blackstock was made outside both periods. He said, to invoke Section 40(3), it must be shown that Mr. Blackstock gave notice in writing to Avant of facts that might give rise to a claim against him as soon as it was reasonably practicable after he became aware of those facts, but before the relevant period of insurance expired. Mr. Blackstock did not do so, and the occasion for Section 40(3) to operate did not arise. The next decision, also involving Avant, was in the federal court. This is the first instance decision, and I was informed last week that an appeal to the Federal Court of Appeal was heard on Thursday and Friday of last week, but I'll come to the significance of that later in the presentation. So between January 2015 and January 2018, Dr. Darshan performed breast augmentation surgery, another acronym, at premises owned or occupied by the Cosmetic Institute, second acronym, or one of its subsidiaries. Dr. Darshan held professional indemnity insurance with Avant from 27 September 2011 to 30 June 2019. Each of the policies covered claims made and notified to Avant. Like Burnie, the policy did not contractually require notification of circumstances. And I just included a little bit of a chronology here so that you can get a feel for the significant events in the matter. So in September 2011, Avant commences cover. Breast augmentation surgery is performed between January 2015 and January 2018. In June 2017, there's a notified HCCC complaint about Dr. Darshan from patient M. In March 2018, Dr. Darshan notified of the proceedings involving a Ms. Scotford. Mackens and Dapperty lawyers were appointed to act for Darshan by Avant. I think shortly after the March 2018. In January 2019, a subpoena was served on Dr. Darshan in the TCI, that is the Cosmetic Institute class action, by a number of recipients of breast augmentation procedures against TCI. February 2019, Mackinson Apogee informed Avant regarding the overlap between the Scotford proceedings and the TCI class action. In February 2019, Darshan phoned the Avant hotline regarding the subpoena which had been issued, and again contacted the hotline in, he did contact the hotline in March 2019 when he notified of the Summers Hall proceedings, also for breast augmentation surgery, and again discussed the subpoena, at which time Avant suggested a copy be sent to them. In June 2019, the Avant cover ceased, and in June 2020, Dr. Darshan was joined to the class action against TCI, obviously after the Avant policy had already ceased. Consistently with the Burnie decision, Justice Mashinsky held that Section 54 does not cure a failure to notify of circumstances under Section 40 where there is no contractual compulsion to notify. He said the preferable construction of the provision is that Section 40(3) and Section 54 stand alone as ameliorative provisions, and their operation cannot be combined so as to make a failure to notify under Section 40 capable of being cured by Section 54. But a more concerning issue was that the court held that by the communications between Mackinson Apogee and Avant, the question which was posed was, did Dr. Darshan, by his agent, Mackinson Apogee, notify Avant in writing of facts which might give rise to claims against him in the TCI proceedings, such that Section 40(3) operates? There was correspondence from Mackinson Apogee to Avant, which described the nature of the TCI proceeding and the causes of action and common questions in the proceedings. It was held that it was apparent that some of the causes of action were potentially open against the TCI surgeons. It was also held to be apparent that in circumstances where the TCI entities had been denied cover by their insurers and were in liquidation, and the liquidators had said they did not have sufficient funds to satisfy any judgment against them, it was possible that the surgeons who had practiced at TCI clinics and performed the relevant breast augmentation surgery would also be joined as defendants to those proceedings. So it was notice given by Mackinson Apogee as agent for the insured. The court held that the sending of the communications was within the scope of Mackinson Apogee's authority to act on Dr. Darshan's behalf in relation to the proceedings, because the communications related to those proceedings and were sent in the course of Mackinson Apogee's retainer as the solicitors acting for Dr. Darshan in the proceedings. It is true that there was also a lawyer-client relationship between Mackinson Apogee and Avant, and the communications could be characterised as the provision of information or advice to Avant for the purposes of its management of the proceedings. While the communications may have that character, His Honour stated, I would nevertheless characterise them as having been sent on Dr. Darshan's behalf for the purposes of Section 40(3). Now, of course, they weren't expressed to be sent for that purpose, but the court nevertheless held that the communication from Mackinson Apogee was sufficient to engage the operation of Section 43, and that Dr. Darshan was therefore entitled to indemnity for that reason. But the court went on to say, and this is an even more concerning issue, I would have thought, for insurers in particular, it held that during the conversations with the Avant hotline, no advice was provided to Dr. Darshan that he needed to send the subpoena if he wanted to be able to rely on Section 40(3). The court also held that Avant were aware of the nature of the TCI proceedings, both through Mackinson Apogee communications and from other doctors it covered. It found that Avant had adopted a position of granting indemnity for other doctors who had submitted the subpoena to them, some allegedly with a list of patients, and that a basis for refusal of the claim was the failure to have provided the subpoena. His Honour held that, but for the finding on notice, that is the finding about Mackinson Dapchi effectively giving notice for Dr. Darshan, he would have held that Avant was in breach of the duty of utmost good faith because it was unfair and unreasonable not to grant indemnity when Avant was aware of the proceedings, would have indemnified had the subpoena been sent, and did not make apparent to the insured the effect of Section 40 when they were speaking to him on the Avant hotline. The breach of, His Honour held that the breach of duty of utmost good faith did not require capriciousness, bad dealing, or a lack of clean hands. I think that's quite a scary decision. I think the potential for an insurer to be required every time they speak to an insured to make sure they understand the effect of Section 40 is exceptional, is the only way I can put it. We'll have to wait and see what happens with the decision of the Court of Appeal, obviously. I'm reasonably comfortable with the agency argument, and I think that's probably likely to survive an appeal, but the good faith argument seems to me to be a little bit more problematic. So we'll watch this space. And Bill is now going to cue the final poll. The final one, fourth. So the question, does a professional services exclusion only exclude liability to the recipient of the services, or does it extend to third parties? Just give people a few more seconds. And we got 50% of people who voted, and the correct answer again is the lawyer's answer. It depends. It depends on the wording of the exclusion, in fact. This is a decision of the New South Wales Supreme Court in Liberty Mutual v SunWater. SecWater owns and operates two dams in the Brisbane River Basin known as the Wivenhoe and Somerset Dams. My apologies to people in Queensland if I've pronounced Wivenhoe wrong. SunWater agreed to provide SecWater with flood management services for the dams. In January 2011, as people in Brisbane will know, parts of the greater Brisbane and Ipswich areas located downstream from the Wivenhoe Dam were inundated by floodwaters causing widespread property damage. In 2017, class action proceedings were commenced on behalf of group members who had suffered damage in the flood against SecWater, SunWater and the State of Queensland. It was alleged that in the days leading up to the 2011 flood event, insufficient releases of water for flood mitigation purposes were made from the dams, which meant that when extreme rainfall occurred on 9, 10 and 11 January 2011, the dam operators were forced to release large volumes of water, exacerbating the impact of the flood on downstream urban areas and group members' properties. The claim against SunWater for negligence, including on the basis that SunWater was liable for breaches of duty committed by its employee, Mr. Robert Eyre, who was acting as the senior flood operations engineer at the time. There was no dispute that the services that SunWater's employee, Mr. Eyre, provided in his role as senior flood operations engineer was a professional service. It was submitted that SunWater was not itself rendering a professional service, but was merely providing people to provide services. The general exclusion 8 you can see there. It excludes liability for claims arising out of the rendering of or failure to render professional advice or service for a fee by the insured. The court returned to those principles of construction, which I dealt with in the second COVID test case. An insurance policy is a commercial contract and should be given a business-like interpretation. The meaning of a commercial contract requires consideration of the language used by the parties, the surrounding circumstances known to them, and the commercial purpose or objects to be secured by the contract. A construction that would defeat the commercial purpose of the contract of indemnity is to be avoided. And exclusion clauses are to be interpreted by construing the clause according to its natural and ordinary meaning, read in the light of the contract as a whole, and where appropriate, construing the clause contra preferential in the case of ambiguity, although this is a rule of last resort. I'll keep highlighting rule of last resort. An exclusion clause should not be interpreted so as to circumscribe excessively the insuring clause. The court held that the exclusion in this case is expressed by reference to claims arising out of the rendering of professional advice rather than claims arising out of a breach of a professional duty, which some of the exclusions do use that phrase. If a claim arises from the rendering of a professional advice or service, it might not arise from a breach of professional duty. So you can provide a professional advice or service without necessarily breaching a professional duty. The question of whether for the exclusion to be engaged was it only the liability, sorry, the question which was asked was it only the liability to the person to whom the services were provided that was caught, or did it extend to the liability to third parties? The court held there is no textual support for reading down the exclusion so that it applies only to claims made by the intended recipient of the professional advice or service. Importantly, SunWater had claimed indemnity under the general liability provisions of the primary policy, but the court noted that the primary policy also provided professional indemnity cover, which was an important matter the court held because a construction of the exclusion as excluding liability for a claim in professional negligence in circumstances where the same policy provided professional indemnity cover does not seem to me to produce an uncommercial or unreasonable result, or to circumscribe unduly the ambit of the cover afforded under the general liability provisions of the policy. But again, I think a sensible interpretation of the professional services exclusion, which come in a variety of shapes and sizes and a variety of terms, but it is, in my experience, one of the more popularly contested exclusions. I've got at least one question which I'll do my best to answer, but please keep an eye out for our next seminar, which will be in late March, next webinar I should say, which will be in late March, although perhaps by late March we might be having people actually attending. And it'll be by our workplace partner, Alicia Materi, on the latest developments in employment practices law. So on that note, I will open it up to questions. I did have one question, which concerns credit hire. The question was, when I've looked at recent right to drive invoices, and for those who don't know, right to drive is a popular provider of replacement vehicles, often at a premium. When I've looked at recent right to drive invoices, I've noted that the kilometres in and out aren't inserted. Are these details important in terms of need? In answer to the question, I don't think that the kilometres in and out are important in terms of establishing need, because the use of, I think the High Court held firstly that owning the vehicle was probably sufficient prima facie evidence to establish that the deprivation of the vehicle was a loss of amenity, which was compensable. But in any event, I would have thought that the kilometres in and out don't necessarily establish need. What they perhaps do establish is the extent to which the vehicle might or might not be used. So I hope that answers the question. I've got the benefit of being behind a computer screen, so I can't see whether that satisfies the person who asked the question. Hopefully it did. Are there any other questions? No? All right. On that note, I wish you a lovely afternoon and a good rest of the week. Thank you very much for attending.